Welcome to No Opinion. My name is Terrell Hussein, and this is a very special. I wasn't going to do this one because I just finished doing my first two recordings, but this came out when I got done, and what I'm referring to is the petition that former President Donald Trump has issued against District Attorney Fani Willis. As I was reading through this document, it became apparently clear to me this thing is well done. This is a well-written argument, and it was written in such a way that I'm going to read it a little bit differently, in that I'm going to read it with the tone that it was intended to be read with. This is not going to be a reading of just reading the words and putting all the numbers out there. This is an argument. This is an argument that you would have if you could just have time to write out your argument completely the way that you want it written and have it cover everything that you wanted to cover. So again, this is no opinion, but if you have an opinion, I welcome you to enter your opinion into the comments below as I read this document, which is essentially going to be what all they're going to discuss next week. This is going to be the main topic of discussion. They're going to pick little pieces out and they're going to cover it. But how many people have actually read it or heard what was actually contained in the document? And thank you for being here, because you're about to hear exactly what the petition says. In the Supreme Court of Georgia, President Donald J. Trump, petitioner, versus Fani Willis, District Attorney, Atlanta Judicial Circuit. Honorable Robert McBurney, Superior Court, George, Atlanta, Georgia. Respondents. Original petition for writ of Mandamus and Prohibition. Introduction. This is an original petition for writs of mandamus and prohibition against respondents, the district attorney and superior court judge of the Atlanta Judicial District. It seeks to both compel respondents' compliance with the lawful duties of their offices and bar their further contortion of the legal process, whose object is petitioners' irremediable injury. The circumstances involved in the Fulton County Special Purpose Grand Jury investigation into the 2020 election, in whose crosshairs the district attorney has placed petitioner. The injuries include reputational harm to the petitioner as he seeks his party's nomination for the presidency of the United States via a flagrant disregard for and violation of his fundamental constitutional rights. And while an original petition in the court is disfavored, the extraordinary circumstances here justify it, particularly since petitioners' every attempt to seek redress in the normal course have been ignored, and the district attorney has given every indication that the injury is imminent. Some 19 months ago, the Superior Court of Fulton County indulged the request from the Atlanta Judicial Circuit District Court to impanel a special purpose grand jury to investigate the facts and circumstances related directly or indirectly to possible attempts to disrupt the lawful administration of the 2020 election in the state of Georgia. That body convened regularly for 8 months until January 2023. Dissolution. Always at the district attorney's direction and under her guidance, cloaking itself with the imprimatur of the special purpose grand jury's authority. The district attorney's office compelled the testimony of over 75 witnesses, many via material witnesses warrants, criminal investigative tools that were beyond the special purpose grand jury's lawful purview. All the while, the district attorney was laboring under the impermissible and actual conflict of interest, hosting and headlining a fundraiser for the political opponent of one of her investigation's targets. Excuse me. Having completed the district attorney's business, the special purpose grand jury has since been dissolved. It has been approved a report whose full contents, recommendations, and authorship are as yet uncertain, since the report status remains in limbo. Nevertheless, the district attorney has signaled that she will use the report, itself the fruit of a contorted and co-opted process, to secure an indictment within weeks, if not days. Petitioner moved to quash its report and disqualify the district attorney. Petitioner asked that a different judge hears his motion, but respondents, the same Superior Court judge who supervised the special purpose grand jury up to its dissolution, asserted jurisdiction. More than 100 days have passed since that filing, and the supervising judge has yet to rule. Not even issued an adverse but appealable ruling, while the petitioner is contemporaneously seeking an extraordinary writ from the Superior Court, resolution, or on even an expedited timeline under UNICEF CTR 6.7 would not outpace the grand jury proceedings, in which case the damage will have been done. Thus, stranded between the supervising judge's protracted passivity and the district attorney's looming indictment, petitioner has no meaningful option other than to seek the court's intervention. That should be shocking. Even in an extraordinary novel case of national significance, one should expect matters to take their normal One would expect matters to take their normal procedural course within a reasonable time, but nothing about these processes have been normal or reasonable. And the all but unavoidable conclusion is that the abnormalities below are because petitioner is President Donald J. Trump. Parties to the petition. Petitioner is Donald J. Trump, 45th President of the United States. Petitioner seeks writs of mandamus and prohibition against respondents with respect to their official duties as the district attorney and Superior Court judge of Atlanta Judicial Circuit vis-a-vis the Fulton County Special Purpose Grand Jury convened to investigate alleged attempts to disrupt Georgia's 2020 election. Respondents are Fannie Willis, Esquire, in her capacity as Atlanta Judicial Circuit District Attorney, and Honorable Robert McBurney, in his capacity as the judge of the Superior Court of the Atlanta Judicial Circuit. Respondent Willis, District Attorney, requested the convention of the Special Purpose Grand Jury to investigate alleged criminal conduct with respect to the 2020 election. She now seeks an indictment, the basis for which would be evidence unlawfully obtained during the Special Purpose Grand Jury's proceeding and the Special Purpose Grand Jury's report itself. Respondent McBurney, supervising judge, oversaw the Special Purpose Grand Jury's proceeding, asserted authority over, but has declined to rule on petitioner's challenges to the Special Purpose Grand Jury's process and retained decision-making power to disseminate its final report publicly. Further, the supervising judge opted to classify the Special Purpose Grand Jury's proceedings as criminal, which provided to the district attorney tools to, inter alia, compel the production of evidence, overcome claims of state and federal sovereignty immunity, and to otherwise secure evidence that she could not lawfully have access. Relief sought. To redress the former and forthcoming consequences, the respondent's mishandling of the Fulton County Special Purpose Grand Jury proceedings, petitioner seeks writs of mandamus and prohibition, directing to quash the Special Purpose Grand Jury report and barring its or its content use in future proceeding, civil or criminal, forbidding the district attorney from introducing any evidence obtained via the Special Purpose Grand Jury process to a regular grand jury, and compelling the district attorney's disqualification as a party representative in any proceedings involving petitioner. Statement of jurisdiction. The court has jurisdiction under Article 6 and 4 of the Georgia Constitution of 1983 to issue process in this nature of mandamus, prohibition, specific performance, quo warranto, and an injunction. That jurisdiction is rarely invoked. However, the preferred course is to petition for extraordinary relief in the Superior Court and appeal for an adverse decision. Brown v. Johnson. Petitioner has identified no case in 40 years where the court has accepted jurisdiction of an original petition. Then again, never has there been a case like this one, and the court has always acknowledged that there will be extremely rare situations in which there is a need for the exercise of the court's original jurisdiction. Graham v. Cavender. Petitioner urges the court to exercise jurisdiction over this petition. Although this court has never outlined what considerations would support its assertion in that regard, the Superior Court of the United States has its rule is illuminating. Issuance by the court of an extraordinary writ is not a matter of right, but of discretion, sparingly exercised. To justify the granting of any such writ, the petition must show that the writ will be in aid of the court appellate jurisdiction, that exceptional circumstances warrant the exercise of the court's discretionary powers, and that adequate relief cannot be obtained in any other form or from any other court. U.S. Supreme Court, R20. Moreover, petitioner's case easily satisfies even that rigorous standard. First, the writs of the petitioner, the writs petitioner seeks would be in aid to the court's appellate jurisdiction because it presents issue that only this court may review. U.S. Alecky Expression Association versus United States, where, as here, sole appellate jurisdiction lies in this court. Application for a common law writ in aid of an appellate jurisdiction must be to this court. Petitioner's lead claim is that Georgia's special purpose grand jury scheme is facially unconstitutional under the 14th Amendment and Article 1 of the Georgia Constitution. Were that claim to arise in the normal course, any direct appeal of an adverse decision would be this court, not the Court of Appeals, under Georgia Constitution, Article 6. What is more, the novel issue in this case, inter alia, whether a special purpose grand jury may utilize criminal investigative tools, whether a district attorney laboring under an actual conflict of interest may continue in a proceeding, and whether a district attorney can rely on otherwise privileged evidence unlawfully obtained by a special purpose grand jury in seeking an indictment. 1 second. Are all of great gravity, concern, and importance to the public. So, would prompt this court's territorial jurisdiction, even if a superior court and the Court of Appeals were to pass on them first. Georgia Supreme Court 40, R40. Second, That this case is extraordinary goes almost without saying. No prosecutor, state or federal, has ever indicted a former president for conduct committed while in office, nor close to home. Has any Georgia prosecutor ever unconstitutionally and so publicly weaponized the special purpose grand jury process, as the district attorney has done here? Also, the posture of this case is unique. A defendant in the normal course of a criminal prosecution could only challenge past illegality via motion. Here, though, respondent's unlawful conduct is on full display, and petitioner has a chance to prevent the further illegality before it happens. Moreover, the litany of errors tied to respondent's conduct, unprecedented interpretations of the special purpose grand jury scheme, state and federal sovereignty immunity, the speech and debate clause of Article 1 of the United States Constitution, attorney-client privilege, executive privilege, the authority to compel out-of-state targets of an investigation to provide evidence in support of their eventual indictments, and whether a local prosecutor even has jurisdiction to investigate and charge a federal official for conduct while in office. And because of the stakes involved up to and including looming national election, review by the court of the state law issue at least is eventually inevitable and appropriate now. Not to be overlooked in that regard is timing. Criminal process, particularly in Georgia, can be ponderously slow. Of the 5 direct appeals from convictions in the Superior Court of Fulton County that the court decided this term, Blocker v. State, Head v. State, Davis v. State, Copeland v. State, Williams v. State, the average time for indictment to affirmance was 12 years. As the court considers this petition, one Fulton County Superior Court courtroom is 7 months into jury selection for what may become the longest criminal trial in state history. The notion that this issues in this petition would timely bubble up to this court through the quagmire of its normal process is grossly unrealistic. If matters this significant and this urgent are not sufficiently extraordinary to trigger this court's original jurisdiction, nothing could be. Relatedly, third, petitioner cannot obtain adequate relief from any other court, and he has tried. On 20 March 2023, 32 days after supervising judge published portions of the special purpose grand jury final report, petitioner raised the issue in this petition via a motion to quash the report and disqualify the district attorney. The state responded on 15 May, and the supervising judge has disallowed any further reply. The intervention of several uninvited amic and media interventions notwithstanding. Meanwhile, the district attorney, citing security concerns, has asked that the Superior Court of Fulton County be on the public on certain dates in July and August, presumably for proceedings related to this matter. If an indictment issues before the supervising judge rules, the process will have worked its mischief, and petitioner will be struggling to disentangle himself from a net that was not lawfully cast. Neither would a petition for an extraordinary writ in the Superior Court be any more effective than a petitioner's motion to redress his injuries, as the process of litigation followed by review could not be sufficiently expedited. Bottom line, this court is the only one that can timely and decisively resolve this matter. Petitioner asks that it does so. This is going to be a long read, folks. As petitioner has noted, in the 40 years that this court has original jurisdiction over petitions for extraordinary reliefs, not once in this time has it found any case to have been sufficiently extraordinarily to warrant an exercise of that jurisdiction. If petitioner's case is not sufficiently extraordinary for the court to exercise jurisdiction, no case could be, and the court should say so. Statement of standing. Petitioner has standing to seek relief. Georgia law has long acknowledged that the subject of a grand jury's report has standing to seek quashal on the basis that the report or portions thereof were unlawful. Example, in Floyd Century grand jury presentations for May term 1996, Harris v. Edmonds, petitioner was an object of the district attorney's pursuant from the beginning to the end of the special purpose grand jury process. And as petitioners demonstrated below, the report is the fruit of a process that was both unlawful on its face and unlawful in its application. Petitioner has the right to seek redress. Further to the point, petitioner's lead argument is that the scheme that authorized the special purpose grand jury is too vague. Even a procedural statute to constitutionally administer under any circumstances the report targeting petitioner, therefore, could not have comported with the process of law, that he was due under the 14th Amendment and the first of the Georgia Bill of Rights. For this reason, too, petitioner has standing to challenge the special purpose grand jury scheme because the only prerequisite to attacking the constitutionality of a statute is a showing that it is hurtful to the attacker. Both Fancy Products Incorporated versus Rayburn Century BD of Commerce, quoting Stewart versus Davidson, Georgia 760. Argument for relief. Petitioner now sits on a precipice. A regular Fulton County grand jury could return an indictment any day that will have been based on a report and predicate investigative process that were wholly without authority. Indeed, the supervising judge on 11 July and in front of television cameras volunteered to oversee the selection and swearing in of the grand jury that will hear the evidence in support of the district's attorney's proposed indictment related to the 2020 election. The judge volunteered to do so while knowing full well the petitioner's motion vis-a-vis the use and release of the special purpose grand jury's report is pending before him. Thus, between the district attorney's driving the process and the supervising judge in action, petitioner is at the mercy of state actors who have here therefore to pay no regard to his rights, even his right to have his motion heard and ruled upon. Petitioners resorts therefore to a prayer for a relief from this court. This court should order the supervising judge to quash the special purpose grand jury's report and bar its use in regular grand jury proceedings. Petitioner's first concern is that the report itself, left untouched, the report's existence will allow district attorney to circumvent normal presentation of evidence and could invite new grand jury to uncritically ratify the previous one's findings. Excuse me one second. And uncritically ratify the previous one's finding. It is one thing to indict a ham sandwich. To indict a mustard-stained napkin that it once sat on is quite another. One-sided as its proceedings are, a grand jury can be no great security to the citizens against vindictive prosecutions by the government or by political partisans or by private enemies. If they perform only in a summary fashion, Joseph Story, Commentaries on the Constitution of the United States, that's like a citing. As discussed briefly above, the remedy for ultra-virus action of the grand jury is the expungement, or here, quash, of its report. Example, in regards to Floyd Century grand jury presentations, 225, Georgia. If the report was unlawfully produced, no one, the district attorney included, should have it to use. And the report at issue here was, to be sure, the whole of Georgia's special purpose grand jury scheme is so unadministrable as to be facially void. Ergo, it is not possible for this or any special purpose grand jury to act within the law. A Georgia's special purpose grand jury scheme is unconstitutionally vague. A law fails to meet the requirements of the due process clause if it is so vague and standardless that it leaves the public uncertain as to the conduct it prohibits, or leaves judges and jurors free to decide without any legal fixed standards what is prohibited and what is not in each particular case. Gallego versus Pennsylvania. In Gallego, the court considered a Pennsylvania statute that governed how jurors determine what court costs an acquitted defendant should pay. The statute said, relevantly, in all cases of acquittals by the petit jury on indictments for offense other than felonies, the jury trying the same shall determine by their verdict whether the county or the prosecutor or the defendant shall pay the cost. And whenever the jury shall determine, as foresaid, that the defendant shall pay the cost, the court is in which the said determination shall be made shall forthwith pass sentence to that effect, and order him to be committed to the jail of the county until the costs are paid, unless he gives security to pay the same within 10 days. The court determined that statute to be unconstitutionally void and susceptible to arbitrary enforcement because it provided no standard, no determine what the court cost would be or should pay them. The law, the court explained, must be one that carries an understandable meaning with legal standards that court must enforce. The court held similarly in Jekyll Island State Park Civic Authority versus Jekyll Island Citizens Association. There, it considered former OCGA, which governed how much the Jekyll Island State Park Authority could charge leases and fees. The annual amount of any fee charged to a person, natural or artificial, or upon any property owned or leased by any such person under the paragraph shall not exceed the annual amount which would be levied for such services by the county of Glen in the form of ad valorem taxes, if such services have been provided by the county of Glen. The court held the final sentence of that statute to be unconstitutional, vague, and indefinite because it provides insufficient objective standards and guidelines to meet the requirement of due process. The statute governing special purpose grand jury suffers similar infirmities. The special purpose grand jury statute has empowered, quote, the Chief Judge of the Superior Court of any county to which this part applies on his or her own motion or petition of the District Attorney or on petition of any elected public official of the county or of a municipality, I can't say that word right now, municipality lying wholly or partially within the county may request the judges of the Superior Court of the county to impanel a special grand jury for the purpose of investigating any alleged violations of the law of this state or any other matter subject to investigation by grand juries as provided by law. Having first impaneled a special purpose grand jury, a circuit chief's judge must then assign a judge of the Superior Court of the county to supervise and assist the special grand jury in carrying out the investigation and duties. The judge so assigned shall charge the special grand jury as to its powers and duties and shall require periodic reports of the special grand jury's progress as well as a final report. In fulfilling its charge, a special purpose grand jury may compel evidence and subpoena witnesses, inspect records, documents, correspondence, and books in any department, agencies, board, bureau, commission, institution, or authority of the state or any of its political subdivisions, and require the production of records, documents, correspondence, and books of any person, firm, or corporation which relate directly or indirectly to the subject of the investigation being conducted by the investigative grand jury. When the special purpose grand jury issues a report, the supervising judge decides the investigation is complete. The judge can recommend a special purpose grand jury's dissolution, and the circuit court judges must vote whether to dissolve the special purpose grand jury. If circuit judges opt not to dissolve a special purpose grand jury, the chief judge shall instruct and charge the special purpose grand jury as to the particular matters to be investigated. ID. And the special purpose grand jury itself will determine how long it will continue to exist and fulfill its charge. All that seems reasonable at first blush, but once one broaches questions of administration, the statutes are quickly found wanting. Are a special purpose grand jury's proceedings civil or criminal? What role does requesting authority here the district attorneys play vis-a-vis supervising judge? What must special purpose grand juries' interstitial reports contain, and may they be disclosed? What rubric does a supervising judge apply to determine whether an investigation is complete or would support a recommendation to dissolve? By the same token, how is the supervising judge, or for that matter, the judge's colleagues in the circuit, to determine whether a report or investigation is satisfactory? Must the circuit judge consider the special purpose grand jury's report or the course of the investigation before they vote on the dissolution? If the judge rejects dissolution, how does the chief judge know what to instruct the jury on? Assuming a circuit judge rejects a special purpose grand jury's dissolution, how long may the grand jurors extend their own service? And how would any of this get reviewed? The special purpose grand jury statutes offer no answer, nor, for that matter, do the regular grand jury provisions, which also govern special purpose grand jury proceedings. See OCG A 1512-102. But the answers matter, and the scheme's silence with respect any governing standards, has licensed the district attorney and the supervising judge's arbitrary and capricious manipulation of these processes. The special purpose grand jury scheme is vague about whether such proceedings are civil or criminal. Take first the nature of the proceedings. Binding precedent treats special purpose grand juries proceedings as civil. See Kernley v. State. Holding that a special purpose grand jury exercises civil investigative powers has no authority to return a criminal indictment. State v. Bartell, distinguishing the authority of civil and criminal grand juries, also in re Gwyneth grand jury, distinguishing criminal accusatory role of a grand jury from its civil investigative role. It should follow inter alia that a special purpose grand jury's statutory investigative powers would yield to the constitutional doctrine of sovereign immunity. Not so apparently when the district attorney sought testimony from Georgia's Governor Brian Kemp and United States Senator Lindsey Graham. Both interposed sovereign immunity claims. The supervising judge rejected those claims, however, holding that the underlying non-accusatory special purpose grand jury's proceedings were criminal, which it said took immunity off the board. But the supervising judge was happy to change posture when the shoe squeezed his other foot, according to the grand juror's post-dissolution interview. The grand jurors whom the supervising judge had a duty to instruct drew adverse inferences about the credibility of witnesses who invoked the Fifth Amendment privilege. Such inferences are permissible only in civil proceedings, not criminal ones. Compare Baxter versus Palomalo and Griffin versus California. So the supervising judge appears, at least tactically, to have waffled on the nature of the proceedings as the circumstances dictated. More than that, though, he doubled down on his error, pondering rhetorically at a hearing on the matter, which was broadcast online and available to the special purpose grand jurors. But if the witness invoking privilege did nothing wrong, why aren't they talking to the grand jury? The consequence of this back and forth was that the special purpose grand jury based its final report on unlawful evidence that either it could not have compelled in a civil proceeding or that it could not have considered in a criminal one. The statutory scheme fatalities opened that crack, and the supervising judge widened it as he saw fit. The special purpose grand jury scheme is unconstitutionally vague with regards to the contents and disclosure of interstitial and final reports. A second issue pertains here whether the supervising judge should publicly disclose all or part of the special purpose grand jury's final report. Again, 1512. 101A offers no guidance. It told the supervising judge only that he was obligated to require interstitial and final reports. It said nothing about what to do when he got them, what they should include, what form they should take, whether someone named in the report should have an opportunity to review and object to its contents, or what protections those named in a report should have. The district attorney, along with the media interviewers, argued whether the final report was a court record under UNF Supreme Court R21, a special presentment under OCGA 1512-71 and 80, in which case disclosure was within the grand jury's discretion, or some third thing. The supervising judge declined to invite respondents' views, or for that matter, the views of anyone else whom the report may name, and held without citation or analysis that immediate disclosure to anyone other than the district attorneys would breach the fundamental fairness. The supervising judge neglected, however, and the statutory scheme declines to provide an opportunity for parties like the petitioner, whom the report doubtless impugns, to challenge its content as ultra-vires or unlawful. In Floyd Sensory Grand Jury Presentments, 225 Georgia, approximately 701, 707. Authorizing the subject of a grand jury report to seek its expungement. Thus, despite having recognized the due process implications of his decisions, Lisby, wow, that's a good one, Liscienba versus California, 314, a denial of due process is the failure to observe the fundamental fairness essential to the very concept of justice. See Snyder versus Massachusetts, 291 U.S. 97. 1934. He declined to afford petitioner the minimum incidence of the process he was due, notice, and an opportunity to be heard at a meaningful time and in a meaningful manner. Fuentes versus Chavin, quoting Armstrong versus Manzo. In doing so, the supervising judge has anointed the district attorney with what she sought from the start: unconstitutional powers that petitioner and others neither challenge nor shield against. B. The district attorney and supervising judge applied the special purpose grand jury statutory scheme as in an unconstitutional matter. As demonstrated above, the special purpose grand jury scheme is unadministrably vague. It lacks clarity on essential points, has given district attorney and supervising judge carte blanche to pull standards and procedures out of the thinnest of air. And so, the district attorney, with the supervising judge's indulgence and protection, has subverted the process and made of it an unregulated, jury-rigged investigative weapon to use against petitioner. Even if this court were to conclude that the scheme itself was not void for vagueness, United States v. Harris, it should still hold the respondent's application of its violated the 14th Amendment Due Process Clause, as well as Article 1 of the Georgia Constitution of 1983. That is particularly so with regard to the Superior Court having classified the special purpose grand jury proceedings as criminal. If arguendo, the statutory scheme was not unconstitutional in that regard, respondents' subversion of it was. As discussed above, the supervising judges having classed the special purpose grand jury proceedings as criminal empowered the district attorney to have access pieces of evidence that she could not otherwise have obtained. Chief among them were the testimony of Governor Kemp and Senator Graham, whose claims of constitutional immunity, wholly viable in a civil proceeding, the supervising judge shot down. The venom spread further than that, though. The district attorney was able to compel the appearances and testimonies of out-of-state targets via material witness warrants, which the supervising judge signed, a process that should not have been available. The district attorney circumvented witnesses' Fifth Amendment rights in so doing. Early on, the district attorney sent letters to witnesses whom she intended to subpoena, identifying them as targets in a federal prosecution. A target is a person as to whom the prosecutor or the grand jury has substantial evidence linking him or her to the commission of a crime, and who, in the judgment of the prosecutor, is a putative defendant. U.S. Attorney Manuel, 9/11/151, but there's no comparable authority defining target in Georgia. And while subpoenaing an investigation subjects or targets is permissible to a grand jury proceeding, United States v. Wong, 431 U.S., federal prosecutors take special care to avoid even the appearance of unfairness and to respect defendants' rights. Under Attorney Manuel, the district attorney was less circumspect. She publicly labeled targets with neither apparent reason nor rhyme and offered them no courtesies to insulate their constitutional and statutory rights. This raises the question of what constitutional protections a target should have in a criminal special purpose grand jury proceeding. If there is such an animal, the Georgia Constitution prohibits the appearance before a regular grand jury of a witness name in a proposed charging instruments. See State v. Lampel, 296 Georgia. A grand jury cannot compel the appearance of one accused in a return or proposed charging document. According to Jenkins v. State, Georgia Appellate 16, grand jury has no lawful right to call the accused before it while considering a bill of indictment against him. State v. Butler, the grand jury may compel the appearance of a wife to testify to her husband's alleged crime against her. See generally OCGA 245506. A criminal special purpose grand jury, as the supervising judge deemed this one to be, tasked with investigating possible criminal conduct and drafting a report recommending criminal indictment, thus creates unique problems vis-a-vis privilege against compulsory self-incrimination. U.S. Constitution Amendment v. Georgia Constitution Article 1. Since the special purpose grand jury could not itself return an indictment or consider a proposed one, a strict reading of the case law would empower it to compel the appearance and testimony of any witness, which a subsequent regular grand jury could then rely on to indict that witness. Surely, the special purpose grand jury scheme does not authorize so flagrant an end run around the Fifth Amendment. Further to the point, not only were the district attorney's purported targets afforded no protections, but they also appeared to have been given the label arbitrarily. The target notifications were publicly released in July 2022, but the district attorney abandoned that labeling soon thereafter, likely in response to the supervising judge's admonition that the practice could be problematic for the district attorney down the road. The district attorney's waffling was more than merely inconvenient for the district attorney's public and possibly secret targets alike. Each faced decisions, both personally and upon advice of counsel, about how to conduct themselves in the public sphere, as well as under oath. In the federal context, whether one is a target often instructs that person, that their counsel, how to best defend themselves. That the district attorney's office opted to label some witnesses as targets, which they need not have done, but not others, forces the questions whether any later omission was purposeful. If not, unlabeled witnesses could only conclude that the district attorney designation, her targets, at random, but no one could rely on the legitimacy of their witness status. Therefore, the supervising judge capriciously fabricated a criminal special purpose grand jury, which the district attorney capitalized on, obviated the due process rights of all involved. Consequently, the special purpose grand jury never act consistently with lawful authority, and its report should be squashed. The court should bar the use of any evidence via the special purpose grand jury investigation in any subsequent proceedings. Admittedly, the report's quash without more does not answer the related question of whether to suppress the evidence that the special purpose grand jury relied on in drafting it. In general, suppression of evidence from a regular grand jury proceeding is not an available remedy. See Lample. Also, United States v. Caldra. Quote, grand jury's operations generally is unrestrained by the technical, procedural, and evidentiary rules governing the conduct of criminal trials. But there are exceptions. Suppression is a proper remedy. One, to redress the violation of a constitutional right. See United States v. Gordino. 2, when the state has so comprised the structural protections of the grand jury that the proceedings have been reduced fundamentally unfair, Bank of Nova Scotia versus United States, and even the violation of the statute that implicates underlying constitutional interests. See Sanchez Lamas versus Oregon. Respondents' conduct supports the first and second basis of suppression, which are intermingled. That the district attorney and supervising judge exploited an unconstitutionally vague statutory scheme or contorted a sufficiently clear one. Both violated petitioners' rights under the 14th Amendment and gutted the essential protections of the grand jury process. The district attorney availed herself of an uncertain and unchecked process to compel the disclosure of evidence that she could not have lawfully obtained, thus resulted in the serious infringement of witness privileges against compulsory self-incrimination. The supervising judge facilitated those efforts by reclassifying the special purpose grand jury's investigation as civil or criminal, as suited the district attorney needs, and via the supervising judge's vacillations, the district attorney secured evidence that she could not have otherwise obtained. Of note, classifying the special purpose grand jury as criminal opened the door to the Uniform Act to secure the attendance of witnesses from without the state. That act applies exclusively to criminal proceedings, not civil ones. Thus, the district attorney was empowered to drag witnesses to Georgia from foreign states and extract their testimony under threat of arrest. One inherent protection that the grand jury purports to offer is the independent evaluation of the state's evidence in support of a proposed indictment. Here, though, the district attorney has had unprecedented opportunity to build her case in advance via compulsory criminal process that she otherwise could not have lawfully accessed. Not to mention the Superior Court's having overridden sovereign immunity for her benefit. Unavoidable now is that whatever presentation the regular grand jury receives will have been calculated to circumvent its fundamental independence. Compounding the prejudice is that the grand jurors who will consider the indictment were sworn in by the supervising judge on live television in front of the district attorney and members of the special purpose grand jury team. Indeed, though their faces were not shown, the supervising judge read their names aloud. Under those circumstances and in front of a television cameras, how could the jurors not know whose indictment they would pass on and what they were expected to do with the district attorney's evidence? Any pretense of independence or critical review of evidence is a sham. 3. This court should bar district attorney from proceeding in this matter because she is laboring under an actual conflict of interest. On 25th July 2022, the supervising judge ordered the disqualification of the district attorney's office from any further investigation or prosecution of the Lieutenant Governor Burt Jones due to an actual and palatable conflict. He did not, however, remove the conflicted party and the district attorney and her office from the case entirely. Nonetheless, in entering a limited order of disqualification, the supervising judge recognized that Georgia law clearly prescribes that a prosecutor can be removed from a matter for which its legal conflicts exist at any stage in the proceeding, including the investigative stage. A Georgia district attorney is of counsel in all criminal cases or matters pending in his circuit. This includes the investigatory stages of matters preparatory to seeking an indictment, as well as the pendency of the case. McLaughlin v. Payne, King v. State. The supervising judge was correct that disqualification was the proper remedy for a conflict, but he erred in applying that remedy piecemeal. He should have disqualified the district attorney from the entire proceeding. A prosecutor's ethical conflicts are not isolated or excisable. As the United States Supreme Court recognized in Young v. United States, ex relevata est filth, the existence of an actual conflict does not stop the prosecution of one individual. It, too, the entire proceeding. Quote, this difference in treatment is relevant to whether a conflict is found, however, not to its gravity. Once identified, we may require a stronger showing for a prosecutor than a judge in order to conclude that a conflict of interest exists. Once we have drawn that conclusion, however, we have deemed the prosecutor subject to influence that undermine confidence that a prosecution can be conducted in a disinterested fashion. If this is the case, we cannot have confidence in the proceedings in which this officer plays the critical role of preparing and presenting the case. ID at 811, emphasis had it. End quote. The supervising judge, however, ignored this clear directive by exercising one target of the district attorney's investigation from the others. He thus undermined the fundamental fairness and reliability of the proceedings. Quote, appointment of an interested prosecutor is also an error whose effects are pervasive. Such an appointment calls into question and therefore requires security of the conduct of the entire prosecution rather than simply discredit the prosecutor's decision, the prosecutorial decision determining the effect of this appointment thus would be extremely difficult. A prosecution contains a myriad of occasions for the exercise of discretion, each of which goes to shape the record in the case, but few of which are part of the record. ID at 812. Indeed, the supervising judge ought to have called a halt to the whole procedure, the whole process, rather than let a conflicted district attorney press on. To do otherwise is to tolerate structural error. Quote, furthermore, appointment of an interested prosecutor creates an appearance of impropriety that diminishes the faith in the fairness of the criminal justice system in general. The narrow focus of harmless error analysis is not sensitive to this underlying concern. If a prosecutor uses the expansive prosecutorial powers to gather information for private purpose, the prosecution function has been seriously abused, even if in the process sufficient evidence is obtained to convict the defendant. Prosecutors have available a terrible array of coercive methods to obtain information, such as police investigation and interrogation, warrants, informers, and agents whose activities are immunized, authorized wiretapping, civil investigatory demands, and enhanced subpoena power. The misuse of these methods would unfairly harass citizens, given unfair advantage to the prosecutor's personal interest, and impair public willingness to accept legitimate use of those powers. ID at 811, Calding Wolfram, Modern Legal Ethics 406, 1986. Continuing quote, public confidence is in the disinterested conduct of that official is essential. Harmless error analysis is not equal to the task of assuring that confidence. It is best suited for the review of the discrete exercise of judgment by lower courts, where information is available that makes it possible to gauge the effects of the decision on the trial as a whole. In this case, however, we establish a categorical rule against the appointment of an interested prosecutor, adherence to which requires no substantial calculations or judgment. Given the fundamental and pervasive effects of such an appointment, we therefore hold this harmless error analysis as inappropriate in reviewing the appointment of an interested prosecutor in a case such as this. ID at 814, emphasis added, citing United States v. Sells Engineering Incorporated, 1983. The supervising judge determined the district attorneys have to have had a conflict of interest is conclusive. By leaving the district attorney on this case, her actual conflict notwithstanding, the supervising judge casually erased petitioner's rights to a fundamentally fair proceeding, not to mention the rights of every other affected target. And he forever razed any basis for public confidence in the special purpose grand jury process or anything that follows from it. Petitioner asked this court to do what the supervising judge should have, but did not: command the district attorney's disqualification from these proceedings. Conclusion and prayer for relief. Much ink has been spilled by judges and academics alike over the importance of the grand jury as the bulwark against unjust or improper prosecutions. Whether they serve that function effectively is a matter of debate, but they surely cannot if prosecutors and courts short-circuit the procedural protections grand juries are meant to provide. Yet, at every turn, the supervising judge and this district attorney have trampled these procedural safeguards for petitioners and others' rights. The whole of the process is now incurably infected, and nothing that follows could be legally sound or publicly respectable. What is worse, the supervising judge had myriads of opportunities to protect the integrity of this investigation, but he opted not to. Now it is too late for anyone but the court to intervene. Accordingly, petitioner asks this court to exercise jurisdiction over this petition, stay all proceedings related to and flowing from the special purpose grand jury's investigation until this matter can be resolved, provide for the submission of evidence and finding of facts, issue writs compelling the quash of special purpose grand jury's reports prohibiting the use of any evidence gathered via the special purpose grand jury's investigation, and grant any other relief that it deems proper under the circumstances. Respectfully submitted on 13 July 2023, Drew Findling, Marissa Goldberg, Findling Law Firm. I'll be honest, I didn't think I was going to make it through that one. I really was not looking forward to doing it, but I know this is going to be what everybody's talking about next week. They're going to be talking about little parts of this document. This document is very well written. It is a strong argument from the position that that argument is being taken from. These boys got off. I ain't gonna lie, they got off. They got their game on big time. This is a good document. But again, my opinion is on the writing of the document, not the contents of the document, not what they're looking to seek to get done. I'm just giving credit for where credit's due, and they earned their money. If you like this kind of information, please like and subscribe, as I will continue to read these documents because they are awesome. They're like little arguments. They're perfect arguments. That if you could have a perfect argument and write out your argument, that's what these documents do. So I will continue on reading these. I encourage you to enter in your comments what kind of information you've taken from this. And if you have an opinion, put your opinion. I'm good with that. My opinion, I don't have one. This is no opinion. I'm Terrell Hussein. Thank you for watching.